Righto, what's this all about? You guys should have been exposed to this just a little bit in doing equity, which is a prerequisite for this subject. Anybody can hear me? You can't hear that. Do you want me to amplify my voice? Okay, let's do this. Audio. How's that? All right, so you should have been exposed to this to some extent with Tina, and she would have talked about remedies, probably, in terms of equity, things happening after, I'm just trying to think of examples you might have done in terms of constructive trusts or resulting trusts being created on particular pieces of property. Does this sound vaguely familiar? I think, again, it's been a while since I've never taught equity. And it's been a while since I did it as a student, so I was at almost 10 years. And I do recall, both in that and in land law as well, Chris mentioning, might have been, or Jamie for me, mentioning how these things can arise through operation of law. And somehow that was unusual or exceptional and only happened when the court deemed it so as some form of remedy. Now, the way that we're going to go really about structuring this entire subject is it's going to be almost like a flower. We're going to start off with essentially the very core of what we're doing, and basically to explain that, when you're explaining what the inside of a flower is, you kind of have to describe the whole thing. And so that's what we're going to do. First week, I'm going to tell you everything. So if you're only going to come to one class, hopefully you're going to learn essentially all of trusts, or at least all you can learn in 90 minutes. Okay, that's what we're going to do today, and that's really what this class is about. It's trying to get an overview of all the things we're going to do, rather than do them in any depth. And so the bits we're talking about, you're going to be doing in more depth at some stage later. And so that's essentially what it is. But when we think about what a trust is, where it sits on the property diagram, we know that equity remedies defects in the common law. Rachel would have taught us that a long time ago for me, but we're not quite as long for you guys. The whole purpose of equity is that it sat side by side with the courts of common law, where there was some grave injustice that the harsh, rigorous common law rules would force upon unsuspecting people going through the main court system. Now, one thing that the courts did realize a long, long time ago in terms of the relationship between common law and equity is that property, and particularly the passing on of property, you don't really think about real property. What's real property, Matty? Land. Land was important. Land has always been important. If you go back to the days of ye old England, and I'm going to be a little bit gendered in terms of language. The subject has a lot of gendered language. And so I will say the lord of the manor, the estate, the section of land, the region, would be a baron, wanted to be able to have the land passed down through the family. And you had to really protect yourself in some way against incompetent children. Because incompetent children, come on, we've all seen those. Maybe we've been one. Maybe we have one. But it's a risk that you, as the head of the family, with land's been passed down for many, many generations, something you had to deal with. And so the courts of Chancery, remember, they were run by priests. And so the priests would accommodate this need to have this long-term custodianship, because from time to time, a 4-year-old, through succession law, might end up being the lord of the manor. What do you do? 4-year-olds are not very good at running large estates. They're not very good at telling people what to do. And if they are the person who is now lumped with essentially this responsibility, that system's not going to work at all. And so the courts, the church, I should say, which we call the courts of Chancery, developed these systems whereby you could split the legal title and the equitable title to property. And trusts fundamentally are about that split. The legal title is the person whose name is on the deed in the case of land, or the person who, for all purposes, with the rest of the world looking in on this situation, the person who owns it. All right, as the person who owns it in common law, but the beneficial interest, the good bits. We think about the good bits and the bad bits of owning property. So, Sean, what are some good bits about owning property? Sorry, the trouble is I know most of your names, so I'm going to just pick on your class. Yeah, it's awesome. Yep. Yeah, you can kick people out. You can let people in, you can kick people out, you can get profits. In other words, if you've got your house, and I got a little house around the corner, and I can, assuming that I had legal title to it, which strictly speaking I don't, I've only got a beneficial interest, but we'll come back to that. Assuming that the person who has legal title can kick people out, can sublease. You can create lesser estates across real property, or you can hire out personal property. Some forms of choices of inaction, things like copyright, for example, you can, through the statutory regime, you can go through and give and grant contractual rights for people to use those things. You get all the good bits. These are the good bits. They usually involve money, essentially. Quite a contemplation and quite enjoyment of your land. You get the right to sue a nuisance. What else do you get to do? What else is good about property? You can live in it and use it, and you can trash it. If you want to, in your house, to leave mess everywhere, you can leave mess everywhere. You don't have to care. It's yours. Okay, these are the good bits about owning property. And most importantly, though, you can alienate it. If you own something, you can sell it or gift it to other people. Those are the good, fun bits that come with having property. And it's one of those tricky things, by the way, teaching this to you guys and appreciating the importance of trust and trust law or property law generally. Generally, you guys, as those going to go into the legal profession, you're learning this now. By and large, you won't have accumulated much property over the course of your life. And so the systems you're learning can be really helpful. Tax is the other one as well. Learning trust law and learning tax to be able to plan your life as you go and actually start accumulating stuff. Because, and the reason why trust law has this bad reputation as being an avoidance mechanism, trusts must have property. It's fundamentally what this thing is about. Separating the good bits and the bad bits of owning property. So again, thinking about real property. Isaac, what are some bad bits about owning property? Yeah, you've got to pay rates. You've got to pay, by and large, unless you roll the dice, you've got to pay insurance. You've got to have all utilities. You've got to maintain the thing. You've got to go through the hassle of going to the courts to exclude others from it. That idea, we get these rights and nuisance and trespass to land and things like that to exclude others, but we are the ones who have to go and actually enforce that. It can be something of a burden of going through and doing these things. These are the bad bits. And so that's really what this is about, separating the good bits and the bad bits. And our legal system lets us do this in equity. It doesn't let you do it at common law. Okay, a couple of things to note here. I'm going to go through, you guys may have noticed me doing admin, I was usually pretty light in terms of describing cases. Here though, I'm going to try, wherever I can, to actually go through and talk about some of the cases, because you'll find a lot of the exam questions will actually follow, not so much the test, but the exam questions are going to follow factually a bunch of the cases there. And so I'm just going to go through and talk about them. Sometimes they're going to relate to multiple parts of the course. So I'm going to try ideally to explain the facts once and then talk about the relevant principles in relation to that. So we'll start with Joliff's, or I'm not sure about this. Tom says Joliff, and Nicholas says Joliffe. No one's got a time machine to go back to 1920 and find out who's right in terms of that. But if anybody does actually find out one way or the other, or you're reading or listening to other material, I'm curious to know. So anyway, this guy, Mr. Joliff or Joliffe, set up a bank account. It was in his wife's name. And this was just after the First World War. Sets it up, and it says, this for the benefit of Mrs. Joliffe, on trust by or re Mr. Edward or Harold Joliffe. All right, so it was in her bank account was in her name, and then it listed him, and it said something like in relation to or held in trustee of. And the whole reason that he did this was to bypass some of the taxes in the state banking legislation of the time. For a reason, that was why he did that. And so on the face of it, it looked like the courts, this went all the way to the High Court. I think it might have gone to England. I think that you guys may have noticed sometimes with the CLR reports, sometimes you'll actually see that they're actually law reports that have actually gone to the Privy Council before the 1970s, so sometimes from time to time. But there, they looked at this, and the courts examined what was actually going on. Now, you may have heard this maxim in equity, that equity looks to the substance rather than the form. And the courts there said that, look, fundamentally, Mr. Jolliffe here is not really wanting to give this money to his wife. He's really wanting to set it up so that it's some sort of trust structure, but he's just doing it this way in order to defeat the state banking legislation. And so even though it's got, on the form of it, and they're looking on the face of it, it's got his name there, fundamentally his subjective intention was actually to try and go through and set the thing up like it was a trust or a trust situation. And so what the courts there said was that, look, equity looks to the underlying substance of the matter. All right, and that was there's two principles from Jolliffe. One is that equity cares about substance, not the form. But when trying to determine the intention of parties, Jolliffe's case said that it is a subjective test. What are some problems with subjective tests? This is a question to the class. What are some problems with subjective tests? No. Yeah, they do. You've got to get inside someone's head. And look, that's the reason why intention, by the way, the word intention is removed from Samuel Griffith never wanted to put it in the criminal code. It's hard to prove. You're having to determine subjectively what's going on in somebody's head in order to determine whether a trust exists or doesn't exist. And that's really problematic for commercial certainty. And so there is a High Court case from 2011 might be, I think it might have been heard in 2010, called Burns and Kendall. And Burns and Kendall, High Court, and this was unfortunate, it was actually just after I'd studied trust law. So it was a subjective test when I learned this, and had been for almost 100 years. The High Court said, no, Burns and Kendall expressly overruled Jolliffe's case and said that's actually really dumb. A subjective test is one that third parties, when coming in and trying to determine whether property is held on trust or not, can't tell. They're not going to know what's going on inside Mr. Jollife's head. They don't have access to all his evidence. It has to be an objective test, much like contract. Remember Cadalpha and State Railway of New South Wales? There, Justice Mason said, in contract law, it's an objective test. It's not about what the parties are actually thinking when they come together to form a contract. It's about what a reasonable third person looking in would see. And so that is the test that we use these days in Australia. It comes from Burns, B-Y-B-Y-R-N-E-S, and Kendall, which I think is K-E-N-D-L-E? Might be A-L. I think it's L-E. Another thing to note too, rehability, that's from DuPont. You might also notice when you're going through DuPont, I suspect the guy either taught in or lived in New Zealand for a long time. There's a lot of New Zealand cases. And just note that the subject outline, which has the list of cases that Tom and Nicola have decided that they'll assess upon and restrict in terms of what the cases they're going to use in their assessment that those don't have many New Zealand cases in it. So just make note that I've mixed and matched some of these. Now, when we're looking at trusts, and in particular when we're trying to determine what a trust is, a high-level principle, very, very basic, it's the separation of legal and equitable title. The legal title is held by a person called a trustee. The equitable benefit is from the beneficiaries in most situations. Unfortunately, you're going to hear that phrase throughout the subject a lot. In most situations, there are beneficiaries. Okay, so we're going to start by talking about other areas of law and looking at what, if we're trying to work out this is what a trust is, what is it not? Because in trust law, you find that you as legal practitioners later on will be going and arguing one way or the other. If we can't succeed in contract, we want to try and succeed in trust law. If the other side's arguing it's a mere bailment, we're going to argue that it's a trust. Here, whether we're talking about powers of appointment, some of us might be arguing that there's a trust, the other side might be arguing it's merely a gift that's been given from one person to another. And so you need to know where trust law sits in relation to the other areas of law. The subject's difficult to learn in isolation, which is why I think wisely, a bunch of you guys, particularly those that I taught admin last year, and have left this until your fourth year, that's definitely the way to go. Because knowing and being able to reflect upon the other areas of law is a very helpful thing to do. And so we'll start with debt. What's a debt? Debt is a right to claim money from a person. A debt can arise in a variety of ways, usually through a contract. Sometimes it can be through other sorts of breaches, tort, for example, where you've got for whatever reason, the person's decided to settle that particular debt, again, usually through a contract or through some sort of deed. But the key thing to note, and why trust law ends up being in the commercial sphere, is that when you have a debt, it is a personal right to get money from someone. If it is unsecured, in other words, it's not attached through the contract, through personal property, so if it's movable items or to real property. What do we call that when you attach some sort of security to real property? It's mortgage. If you don't have a mortgage, you've got some other attachment to the particular person that you've usually lent money to, or you've got some sort of contractual arrangement with. There are going to be situations where you are going to prefer a trust law remedy over a common law one, because by and large, the remedies you can get in equity are much more powerful. They can be associated with things rather than people. Very, very helpful if the particular person has gone bankrupt, or the company's in liquidation. Either of those things are going to apply. These things, by the way, there's no real distinguishing here in trust law between natural people and corporations. There's no distinguishment. There's things, when I say things are personally attached to people, what I mean is that it can be attached to an entity that was sui juris and that can sue or be sued. That's either a company or a incorporated society or a not-for-profit or some other entity incorporated under a piece of legislation, or a natural person. Okay, and this was most famously done, this case we're coming back to pretty much every week when we talk about Quistlo's trusts. This is the case this comes from. So I'm going to start with the facts of this, because you might as well know it now, because we'll be hammering it out again and again and again. Because this is to do with commercial realities. So, in the late 1960s, there was a company called Rolls-Razor. Rolls-Razor. I don't know, presumably they sold razors of some sort. And so the board of Rolls-Razor, they weren't doing particularly well. And yeah, you guys have all studied company law, most of you have studied company law, and you guys know that, sure, there's a whole bunch of duties and equity as company directors that you get, but there's also a bunch of stat duties. One of them is don't trade while insolvent, don't pay dividends when you haven't made any money. But anyway, that's actually a relatively recent invention. So if you go back to the 1960s, the company decided that they would pay, Rolls-Razor would pay dividends to its shareholders. All right, and there's a couple of really important factual points here that make an important difference that you guys, again, from this point forward, I hope you leave this on the back of your mind. All right, because while I say equity looks at the substance, sometimes the form really matters. So they went to their bank and they set up a separate bank account. That's important. A separate bank account called the "We would like to pay dividends" bank account, something to that effect. So Rolls-Razor went to their bank, which was Barclays Bank, and said, we want to set up a separate bank account, and Barclays knew about this. They decided off to create the separate bank account to pay dividends to their creditors. All right, so that's all fine and well. So we're going to pay dividends. We need to get the money from somewhere, but we're not borrowing from Barclays Bank. They actually don't like us much at the moment because we've got a very large overdraft with them. So they went to a third party. They went to Quist Close Investments and said, we would like to borrow some money. Look, we'll pay a pretty high interest rate, but we want to borrow some money in order to do dividends. Seems like a pretty crazy thing to loan money for, but sure. So Quist guys, for whatever reason, accepted that. Cool. They moved the money into that separate bank account. And then, like all of these things, then something bad happens. Rolls Razor got put into liquidation. And so the liquidators, and in particular Barclays Bank as creditors, were then sort of stuck with something of a situation, and it had to go to court. So the first point I'm just going to note, and I'm going to note this as a really important practical consideration. Very, very, very important. Equity and getting remedies in equity and doing anything in equity is discretionary. Did Tina explain to you what that actually means? Did she? What does it mean? Simon? I know you didn't nod, but that's fine. It's all good. What it means is that it's up to the court to decide. You must go to court to get a discretionary remedy. You cannot self-help. So if we go back, and again, I'll use some examples from contract law, which you guys should be pretty familiar with by now. Here's some examples. Say common law duress, which I think I'm teaching next week or the week after. Common law duress is a common law action. You threaten to break someone's kneecap. All right, they enter into a contract. They take the goods. You pay them the money. You're scared of them. What if the enforcer then goes on holiday? All right, you know that this contract's under duress, and at common law, you're going to have this right to undo it. It's voidable. What can you do? If the enforcer's not there, go to their yard, pick your stuff up, and take it back. All right? You're always within your rights to do that. If you're going to go to court, look, you might be wrong. Maybe they didn't threaten your kneecaps. Maybe you would lose in court. But at least you're going to have an honest claim of right for doing it. It is a self-help remedy. You can do that for common law remedies. You can never do that for equitable ones, because the court might just say, nah. And they can say nah for a variety of reasons. What are bars in equity? What are some examples? What are some reasons the court might say no to your claim in equity? Drew? Yeah, what are they? What are some examples? Unclean hands. Yep. They assist the diligent, not the tardy. Latches. Don't delay too long. Equity does not assist a volunteer. No, what's... A shield and a sword. Yeah, that's right. Although that's... Yeah. I remember Rachel doing this when we learned about estoppel. But all of the equitable maxims that the other side could throw up and say, you took too long, or you did something naughty. You were trying to screw us over in bad conscience in relation to the same transaction. Therefore, you ought to not be able to get that. So what that means is that discretionary remedies require you to go to the court. And as a result, Quist Close had to go to court because they were wanting to argue. And this is, again, this case is kind of famous in trust law. But really, this should seem pretty logical. What they argued, successfully, to everyone's surprise, is that we lent the money to Rolls Razor for a very specific purpose. That purpose failed because the company went into liquidation before the dividends could be made. And as such, that money should result back to us. The purpose failed, therefore it should result back to us. And there was a lot of commentary about this at the time. Why? Because usually with trusts that are set up, express trusts that are set up, it's usual that there's some form of identified beneficiaries as a result. We call this the beneficiary principle, or some sort of charitable purpose for going through and doing these things. Here, it was a commercial arrangement, and the courts were happy to accept that it would actually be in bad conscience for Barclays Bank to hold on to that money and just use it to offset the overdraft that Rolls-Razor owed them. That money had to go back to Quist Close. And we will come back to this case because it looks like at the time people were like, this sits alone or it sits outside of the system. But it's actually kind of not, because there are other cases in and around that same time that did very similar things. And one of them was Re-Caford. That was a mail order company that had a bunch. Oh, it was mail order. Mail order. You get things in magazines. You post the thing. Oh no, maybe you guys don't. Back in my day, when I was a lad, you'd get magazines, and you would actually have to fill things in and attach a check or a money order and send things off. So it's kind of like Amazon, but really lame, in that you couldn't look at millions of things. You've just got the one in front of you. And so what these guys did, that Re-Caford, they had set up a separate bank account. Again, this is an important consideration. Set up a separate bank account that was called the Mail Order Customers Trust Account or something similar. They'd set it up and it was separate. For those that have done trust accounts with me earlier this year, I think I would have hammered home the point about mixing from the general trust account to the office account, how that's a big no-no. And it really comes from the principles of trust law. Mixing and matching money is bad. So they kept the separate account, and then when they went into liquidation, Re-Caford, who has got in LIQ, liquidation, was this money to go back to customers. And the liquidators tried everything to try and be able to keep that money, to give it to the creditors, and they failed. Because, sure, some of the people in that mail order company couldn't be identified, right? But most of them could. Most of them you're going to go be sending the goods to. So instead of sending them goods, send them back the money they paid. And it's similar with that Stevens Travel case as well. There's a case we do later on, which modifies this rule slightly, the Caledonia case, but that's like week 10. All right. Key thing to note also about debt, and I don't think you guys do bankruptcy. I think Tom was teaching it, but it's not available this year. When we use the term bankruptcy, that's that point in time. Civil procedure, Keto teaches as well. Does anyone remember doing that? How many dollars do you have to owe to be put into bankruptcy? It's $5,000. And companies? $2,000. That's it. So make note, two things you need to know. First, if you owe $4,999 to one person and to another person, make sure they never actually meet. If you're going to have debts, make sure that your debtors don't even meet. Secondly, if you are a company director, make sure you check your mailbox once a month, or less than that. I think it's 28 days. Because if you get sent one of those and your company gets liquidated, you're going to be in some strife. But the whole point of what we call liquidators in company law and receivers in the trustee in bankruptcy and when it's a natural person who goes bankrupt, but I'll talk about this one largely, is that their job is to take legal title of all of the stuff that belongs to either the natural person or to the company, and they step into the shoes of that person. They have legal title, and they have a specific job to do. And so the receiver or the trustee in bankruptcy or the liquidators in company law, they are trying to sell as much stuff as they can that belongs to the company to be able to repay creditors. They want to go and repay creditors. Now there's an order, there's a little hierarchy in terms of who gets paid. So secured creditors get paid first, then unsecured creditors, and then the people at the very bottom who usually get some fraction in the dollar is the shareholders. The liquidators get paid first as well. They take their fees. That's an important one. But, and this is why people try to use trusts to try and bypass this whole process. Because if you got a trust, like they did for the Quist Close case, if you got a trust over something, the beneficial interest is owned by someone else. And you can't take something that's owned by something else and on-sell it. You're not allowed to do that. The beneficial interest is owned by someone else there. So Barclays Bank, they were owed money in the overdraft, and they were and there was money sitting in a special bank account labelled for this distribution from Quizclose, they weren't allowed to offset those two things. This money, the beneficial interest of that money, was still held by Quizclose, and it went back to them. It doesn't go within the scope of the liquidators, but people try to bypass bankruptcy law and corporate insolvency, and they do that by trying to create trusts. And the rule, oddly, I haven't actually found a case where they've used this exact phrase, but Tom taught me, was when dark clouds are on the horizon. Trust law is set in equity. If you're going to try and set a trust up to defeat creditors, the courts won't have a bar of it. And there are statutory rules preventing it as well. So here they say, literally, transactions that have moved money out of a company account for whatever reason into a trust, whatever, are going to be voidable. The liquidator can come along and say, no, we are undoing that transaction. We have a statutory right to do that. Equity follows the law. All right, so that we hear about those things. You hear it's voidable transactions. Sometimes you use the term preferences. Voidable preference. So the liquidator gets the choice of undoing a transaction that happens close to the point in time of liquidation. Bailment. I don't think we did very much in bailment when I did this as an undergrad law student. I don't remember. I think Tom taught about it a little bit. Maybe, does Chris talk about it in land law these days? Do you guys know what bailment is? Because I'm not surprised that people haven't really been exposed to this. Chrissy, what's bailment? Yeah, to look after, to do for a specific purpose. Bailment is really, really old law. It predates tort and contract by thousands of years. And it used to have a quasi-criminal aspect to it. Because you kind of think about it, if you go back 10,000 years, if there is a goat and you lose the goat, everybody dies. Maybe that's not a good example. You lose your flock of goats so that you were obliged to look after stuff. There was no agreement between your family members or the rest of the village. You had this obligation to take reasonable care. All right, you don't do that, they're going to beat you, poke sticks at you or whatever. So bailment actually predates contract and predates tort. And the rules for it are, when you're looking after other people's stuff, you've got to take reasonable care. And it's a pretty low bar. It's slightly higher if you're paid to do it. There is a coexisting contract. You know, if you're a courier driver or something, there's a slightly higher standard of care. But generally, if your mate lends you their car, you have a duty in law. It's the law of bailment. And if they drive your car like an idiot and crash it and go, oh, sorry, bro, but we didn't agree, well, too bad. Rules of bailment can apply. And so this can happen from time to time when contracts fall over, contracts don't exist, but other people are holding on to other people's goods. I teach this as a module for the MBA, so business students get exposed to this because it happens actually a reasonable amount of time in commercial transaction. So just make note that it's different from a trust because trustees have legal title. All right, so when the settlor was the person who creates an express trust, when they give their stuff to the trustee, they're not just giving it to them for them to look after and then giving it back to you. No. You're vesting legal title in it. You're transferring the name of real property or the legal ownership or registered items of personal property like cars. The name is actually transferred to the trustee. Legal title passes. All right, and whereas Baileys, they've got this, this right to possession and this right to not be disturbed by the bailor while doing their thing with those goods. Contract and tort. Contract and tort. Teaching business law too long. Contract and trusts can coexist, and they certainly did with the Quizlose case. There was a contract, of course there was. It's a debt, borrowing money, paying some interest. But you guys, as law students now, just starting to get a handle on what trusts are, you're going to have a think about in what situations using your contractual rights is going to be better than trying to get something in trust law. And remember, from a practical consideration, if you're going to do stuff in trust law, you've got to go to court. equity is fickle. And so when you talk to practitioners, when you start talking about what about constructive trust, they usually go like this. And so how much money are you going to put into my trust account before we start looking at that side of it? Because it can be long-winded and complex, and only lawyers know about it. I've got some examples, some business-related examples involving constructive trusts that end up being complex when you're dealing with people who don't know anything about the law, particularly equity. So you guys, do you remember, does that Cools and Baggots, does that case seem familiar? Does it look vaguely familiar to you guys from your first year? Rachel would have talked about it. It's the one involving a quarry, where a guy got people to come and quarry his land, and the question was, and give the money to his wife. And then the High Court had to try and work out, well, can the wife sue or be sued on that contract? And the answer is no. She didn't offer consideration. Doctrine of privity applies. Those two doctrines kind of coexist with each other. The Trident case you might remember as well, there where you've got subcontractors that come onto property, whether or not they can get rights from the insurer of the head contractor. But those two things are important because beneficiaries never offer consideration. Beneficiaries do not offer consideration in trust law. They only get the good bits. Trustees have to offer consideration because being a trustee is a burden. And in contract law, burdens and detriments can and are valid forms of consideration. Okay. All right, so now you would have probably heard of those terms. Here's one you probably haven't heard of, which is to do with powers of appointment. That is a technical legal term or legal phrase to do with giving your property to other people for a specific purpose. Giving your property to others for a specific purpose. You can say to somebody, I can say to James, here, take my house and in 3 years' time, give it to my son, for example. All right, they call those powers of appointment, and they come in a few types. And it all comes down to how the power is expressed and the language that is used. And so what they say is that, look, if the language doesn't give strong directory or mandatory words to do something very specific with it, or give that property to very specific people, that is not going to form a trust. We say that they're not trust powers. They do not have this necessary mandatory language to go through and do that. And we call those mere powers. Sometimes you hear them bare powers of appointment. Where yep. If it doesn't have strong language, it's not going to be a trust. So you need to have strong language with clearly expressed intention for that person to do something with your property. Give it to this other party on certain carefully worded conditions. You must take my property and you must give it to my child. A case here is Morris and the Bishop of, I've got it written down. Durham? Is it Durham? Yeah, that sounds right. Morris and the Bishop of Durham. It's a case from the early 1800s. And there, the person giving the things away said to the bishop, apply my goods and give them for the use of your discretion in such terms of liberality and benevolence as you see fit. And there the court said, nah, that's way too vague. You're not mandating them to do stuff. And in most situations, particularly if it's family members, when the thing is given, this power of appointment is given with this vague language, it will be a gift. It is hard to determine sometimes when a person is creating a trust and it's so uncertain that it could never be actually given to them and it remains or returns back to the settler, or it goes to the target. So if I give this to my brother. I say to my brother, you have my property, use it as you see fit, for such purposes as you see fit, to do whatever you so like, and if you deem it wise, give it to my child. It's not going to work. It's not going to be a trust power. It's going to be a mere power. It doesn't have that mandatory language. You guys are probably finding already that this seems a little all over the show. Does it seem a little bit unstructured? I literally thought really hard about the order of going through and talking about these. And it's hard because we're doing essentially the whole subject, and then we're going to break it up. All right, so just some sort of definitional things when we're thinking about trusts. These categories that sort of chop them up. The first is what's called inter vivos, as opposed to mortis causa, I think is a Latin phrase, or dead or testamentary trusts. Living trust versus testamentary. Doing something while what the settlor, the person giving the thing away, is still alive, or having it enshrined in a valid will, and trusts must be enshrined in wills in order to be valid. If that is called a testamentary trust that comes into effect when the person dies. Okay, then we're dividing things up in terms of express trust. That is where there is a settlor, a person given the thing away. And once they've given the thing away, they're not involved anymore. All right, those are known as express trusts. A settlor is giving legal title to the trustee. And that has to be distinguished from trusts that the court say exist. And those come in two flavors, which I've got as point 5, resulting and constructive. Those are the two trusts that occur by operation of law. Constructive trust is a remedy that the court plops across property to make people be trustees where they've done something naughty. Resulting trust is where there's been some defect in creating the trust in the first place, and it results back to the settlor. The trust property will result back to the settlor. Those are trusts that arise through operation of law, all right, which is actually point 5 on my list here. Express trusts can either be fixed, where the beneficiaries are known and can be put into a list. That language is used very specifically because they use the term list certainty. The beneficiaries get the two components of goodness that come from having beneficial interest in a trust. Those that have done tax law, what are the two halves? What are the two halves of goodness that you get from being a beneficiary trust? Capital and income. Beneficiaries cannot get the bad stuff, which is a loss. No matter how much you want to push losses onto them to reduce their tax liability, you can't. They can only get capital and they can get income. And in a fixed trust, the intention of the settlor was to map that out. Say, I have 5 children. They are all going to get this much, or this percentage. In a fixed trust, that can be mapped out in the instrument that creates the trust, in the deed, usually. Or, in some situations, if that isn't mapped out, the courts will try and save trusts. Remember how that phrase, I use it a lot when I teach contract, is the court is not the destroyer of bargains or destroyer of contracts. It's also not the destroyer of trusts. They bend over backwards to try and save trusts that may have some other form of defect in their form. And one of them is a maxim in equity. It's actually enshrined in Section 35 of the Property Law Act. And that is, equity is equality. So if there's some defect where the person has added the numbers up wrong, for example, oh no, I'm giving 20% to you, 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 20% to you. Oh, that's a problem. 25% to you, 40% to you. That's a problem. Doesn't add to 100. That's a defect, clearly on the face of it. the trust can be saved through the maxim equity is equality, which is also section 35 of the Property Law Act. All right, wait for time. 26. Another point is that express trusts can be set up to have beneficiaries, people that get stuff. You want to leave stuff to you, set a trust up for the benefit of your kids, other relatives, friends, family, whoever you like. All of the residents of Douglas, all of the employees of James Cook University, you can do that. All right, but still fundamentally, those are private in nature. There is another mechanism you can use, though, if you want to leave money on trusts, and that is for a purpose. For that purpose, coming back to Quizclose, leave that away a little bit. Generally, purposes have to be charitable in nature. This is an area that changed since I've done the subject 10 years ago. It used to be, and I'll still teach you, charitable purposes were listed. It came from a statute in the reign of Queen Elizabeth, restated in Pemsel's case, P-E-M-S-E-L. And Pemsel's case said that there are 4 types of charitable purposes. They are to the alleviation of age, infirmity, and poverty. They are for the advancement of religion. They are for the advancement of health. Not health. Education, not health. It's in the first one. And the 4th one is for other purposes beneficial to the community. Very broad, open-ended purpose they've left off there. So what is not included in that? Well, health is not strictly speaking. Most of us might fall into the first one. But animals and the environment, no. Pemsel's case is from 1891? Late 1890s. Remember? No one will remember. Anybody who was doing admin law, I might have mentioned this. The Australian Constitution was written about that time as well. Is there any mention of the environment? Is it in section 51 of the Constitution? Nah. The environment didn't exist back then. And animals were there to be eaten. And so those 2 things have changed, but it took a really long time. So the Charities Act, the federal government came together with the states and they've reformulated this to create a bunch of statutory heads as well. So there are some extra ones and we'll go over those. But for the time being, Pemsel's case has got listed and restricted to 4. Okay, I talked about those other types of trusts. All right, elements. What are elements, by the way? This is my contract law class. Were you ever told what elements actually were? Did anybody, Rachel or Jamie, anyone tell you what this actually means? Because I don't know about you guys, and I'm not sure how many of you ended up doing law as under the LLB grad course. There's not many at JCU these days. It's basically you can do a degree in 3 years if you've already done 1 or more degrees in the past. So when we start doing that course, we jump straight into Torts A. And Diane, who talks very, very fast. You guys probably still have Diane for those that are on family law. It's her last year. Oh, I should go and offer my commiserations or congratulations. I'm not really too sure. So Diane puts a lot of stuff, and the first thing on the first slide, or first taught, I think it is, of battery, talking about the elements of battery. That only means something if you know what the word elements actually means, which you guys in 3rd year probably ought to. It is a point of law that must be proved conjunctively. Multiple points of law that must be proved conjunctively. And what do we call points of law that must be proved disjunctively? What are they known as? That's a tricky question. Not sure. Nah. Limbs. There you go. Learn something. You probably already knew all of that, but it needed to be expressed with just a little bit of clarity because that wasn't expressed to us and it took us ages to work out what they're going on about. And the business students, when I teach them things like the tort of negligence, person's being sued for $100,000. They're going to succeed on the first 2 elements, but not the 3rd one. Therefore, they get only $66,000. Wrong. You get nothing. You pay the other side's costs. Elements must all need to be proved in order to establish a particular point of law, be it a cause of action, the defendant unlawfully caused grievous bodily harm, section 320 of the Queensland Criminal Code, or other components of law. To prove that you didn't overbear someone's will and undue influence. You can prove the transaction was reasonable, arm's length, and you took sufficient time to go and encourage them to seek third-party financial and legal advice. Those are points that you get to prove. And so here, I had to actually spend a lot of time thinking about this. This doesn't seem like a lot of thought. This took me ages because all of the books express things in quite different ways. But fundamentally, these are the three things that you must have to have a trust in any of the different combinations and permutations. Notice that it doesn't have beneficiaries on that list. There must be property, because trusts are about the separation of legal and equitable title. That property must be vested in a trustee, sometimes involuntarily. Sometimes they do it because they want to, sometimes they do it because they don't want to. All right? And there must be certainty. I'll explain. Well, we'll spend a whole lecture explaining certainty, but for the time being for today, I'll explain a little bit about what we mean by certainty. We'll start with property. Couple of things. There must be property, and the court has to be able to ascertain what that property is. Why? Because if you go to court and you want to seek some sort of order, the order is made against the thing, not against the person. It's in rem, not in personam. And so to actually do that and get the court order, you have to know what the stuff is. Also, the trustee with duties has to know what it is they've got the duties across. What is it that they're having to go through and deal with? And there's a little bit more complexity when you've got fixed trusts, because one of the trustee's duty in a fixed trust is to give the income out each year and or the capital when the trust is about to end. And you need to know how much to give each person. And again, this is one that can sometimes be saved again by things like the maximum of equity as equality. You have to know what the stuff is. The court has to know, and the trustees have to know. So, trustees, this is an area which is regulated. So, private express trusts are capped. You must have 4 trustees, and they must make decisions unanimously. All right, that's just in the Trust Act. It regulates this component of this area of law. Charitable trusts are essentially like companies. They make decisions by majority, simple majority. All right, you would have learned about fiduciary duties. Fiduciary duties sound familiar? Hospital products. Hospital products is about creating fiduciary duties on the facts when otherwise they wouldn't apply, for example, joint ventures. There are, however, status-based fiduciaries. What are some examples? Maddie, what's an example? Status-based fiduciary. Isaac, go for it. Status-based fiduciaries, business partners, so partners and partners, trustees, beneficiaries, well, that's the whole subject. Solicitor client. Some might argue that in some situations it's going to be financial advisor and client, sometimes, not always. But what's the other major? Company directors. And the company directors owe fiduciary duties to companies, and employees owe fiduciary duties to their employers. Agents owe fiduciary duties to their principal. All of these are status-based fiduciary obligations. They always exist. And the fiduciary duty is a high bar. In fact, I was talking about battlement before. Battlement's probably the lowest bar you could imagine. Take some reasonable care of someone's stuff. Fiduciary duties are the highest duty that we place upon people. You must do these things. You must do them properly. You must do them to the best ability. You must not delegate them. You must do them well. Otherwise, we're coming for your stuff. You can go and ask, the beneficiaries can ask the court to actually recover things from trustees that do things naughtily. Yeah, I mentioned those things there. So trustees, private trusts have got to be unanimous, and you can't delegate. Trustees can, however, use the Trusts Act and the various powers that are given in there in order to hire people to act as agents. So if you're a trustee for a family trust, and the family trust has a house, you can hire registered builders to fix it. And trustees can't hire unregistered builders to fix it. That's going to be a breach of your duties. Something just leave in the back of your mind, because I'd be very surprised if most of you don't end up being trustees of something at some stage. All right, certainties. We talk about the 3 certainties: intention, subject matter, and objects. So before, when I was talking about this difference between mere or bare powers of appointment, or those that are going to be deemed trust powers, is this requirement that the set law intended to create a trust. Wasn't a loan, wasn't bailment, it wasn't a gift. We have to determine that, or the court has to determine whether that exists. If it is a gift, the gift goes to the person you gave the thing to. There's a thing called the presumption of advancement. It says, by default, you give things to your kids. It is deemed by default to be a gift. You have to be really clear about your intention when doing that. Okay, the property of the trust needs to be identifiable. You have to be able to actually identify what the things are. Both the trustees need to identify, and the court needs to be able to identify that with reasonable certainty. You don't, strictly speaking, need to map this out in a huge amount of detail. It can be for a person to go and investigate and find the thing. I leave my rental property in Cairns to my son. All right, if I own 3 properties in Cairns, one of them was rented out, somebody could go and investigate to find that out. Okay, it must be able to be identified with reasonable certainty. It doesn't have to be expressly stated in the deed or instrument itself. And objects. Okay, so there's 2 things: beneficiaries for private trusts, and purposes. We talk about this thing here. This idea that there has to be some form of purpose, and that's going to be a requirement in order for a trust to actually exist. So just make note that I've noticed that this varies between the texts. Some of them say that charitable trusts don't need certainty of objects. They still have to have some form of defined purpose or some existence under the statute where they meet that particular statutory requirement of having some charitable purpose. Express trust needs all of them, and trust by operation of law, so in other words, these resulting and or constructive trusts, they don't have certainty of intention. In fact, they often arise where one or both parties do not want them to arise. It's actually the opposite of that. Certainly, going back to Quistclose, the last thing Barclays Bank wanted was for a trust to be declared. Only Quistclose did. Liquidator didn't. Well, I don't think Liquidator cared, actually, because the money wasn't going to go to them anyway. But often, it's one or none of the parties' intention. And notice also there's a difference between contract law and trust as well. We care about the intention of the set law. In trust law, what do we care about in terms of intention for contract law? What are the elements of a contract? Michaela, whose intention do we care about in a contract? Yeah, both parties. We care about both. Both parties must have a mutual understanding of what it is they're doing for there to be a contract. In trust law, we only care about the intention of the set law. And in trust by operation of law, we don't even care about that because there is no set law. So, going back to express trust, why would you bother doing this? Oh, it's the last slide. 40 minutes. Why would you go through the hassle of doing this thing Now, I'm thinking here in terms of discretionary trusts. I have left out the possibility of us as practitioners going on behalf of our clients and seeking the trust through operation of law, leaving that aside. For express trusts, setting these things up. And again, there's the two flavors. Fixed trust, where we map out the entitlement for each, as opposed to discretionary trusts, where the trustees get to pick every single year whether to give money out or whether not to. All right, that's a very powerful mechanism if you like the trustees and they get along with each other. That doesn't always happen. Just ask Gina Reinhardt. Because the thing is, beneficiaries don't get to choose under discretionary trust whether they get given money in any given year or not. It's going to be down to the instrument and the discretion of the trustees. The one thing they do get, all right, is a mere equity. Do you guys remember there's a difference between a proprietary interest in proprietary equitable interest as opposed to a mere equity? This one is tangible and calculatable and ranks higher in priority disputes than a mere equity, which is a right, in this case, to compel the trustees to do their job. So you, in a discretionary trust, can't tell the trustees to give you money. You can tell them to do their job. And if they don't do their job, your equitable right is to actually go to court and replace them. You might find trustees who are a bit happier to grant you money in every given year. And that is different from a fixed trust where every year you are entitled. You become entitled. You get this proprietary interest in that fraction of the income and, depending on the way the deed structured, the capital as well. There's proprietary interest. And there's a case that I'll talk about next week called Kennan and Spry, where the High Court actually had to re-examine this in the context of family law. There's been a little bit of change relatively recently. So why do you bother doing this with a discretionary trust? Some of these have declined in recent years. The Parliament's jumped in to try and stop them from doing that. Look, Parliament's been trying to do this for a long time. Henry VIII was trying to get rid of these things, and he didn't have much success because the church at the time, the courts of chancery said, oh, okay, Henry VIII said there's no more trust. Okay, sure. So what we're going to have now is a trust upon a trust. So there's no actual trust. We just have a trust to create another trust. It's just this mechanism to get around those systems that the king, essentially, and sitting in before Parliament was really a thing, should try and get all the land off the church. Turns out the church didn't want to give the land, and they controlled the courts of chancery. So, a couple things to note. Separating the benefits and burdens of property. This is the main one, in my opinion. It is basically being able to help those that can't help themselves. The thought of my 8-year-old trying to run the household terrifies me. Dada, why do I need to pay bills? I don't want to pay rates. Just imagine it. So that there is situations where trust can be set up where people can take on the duties and the burdens and leave the good bits for people they care about afterwards. And look, and these things can happen in a variety of situations. Orphans, for example, people that are very, very little that are taking these things, or people that are invalid for whatever reason, can take control of things and look after stuff. Another powerful mechanism was in terms of income splitting. Example might be if what's the top tax bracket now? Is it 210? I know it's moved. Who's just done tax law? Chrissy, what's the top tax rate now? It's more than what was 180. I thought they bumped it up. No? Okay, we'll assume it's 180. Let's just say, is it, Isaac? I'm not sure. It is still 180? Okay. Mea culpa on that one. Assuming that you had a trust, all right, and you've got a bunch of income, we'll say say we've got $100,000 worth of income, all right, and you've got two beneficiaries, we'll say husband and wife. So the husband earns nothing, the wife earns $180,000. Which way are you going to send the income? Send it all to the husband because he didn't earn anything. Therefore, he's going to have a lower marginal tax rate. If you gave it all to the wife, you'll be paying 47.5. Is that what it currently is? 46. It used to be 46.5 cents in the dollar. Again, I thought they'd bumped it up. No, not sure. I haven't checked my numbers recently. The idea is that you can pick in discretionary trusts where that income goes for maximum tax benefit. John Howard, when he was treasurer, put some rules in. It said you can't do this to your kids, or at least, I mean, you can. And for the first $416, that'll be tax-free. Woohoo! And then the next $1,000 or so, $1,020 is going to be taxed at 66 cents to the dollar. Don't try this at home, kids. It won't work. So if you're trying to give money to children that they're not actually earning through personal exertion, either through trust or company, they are going to be paying a punitive rate. And then they pay a high tax rate after whatever it is, $1,400 and something. So it doesn't really work that well these days. Bill Shorten was trying to stop it. Didn't win the election, so it's kind of a moot point. Concession benefits and exemptions, often these are state benefits, but in terms of charitable trusts, you can also be exempt from income tax as well. Succession estate planning, inter vivos trust, particularly with corporate trustees. A trustee can and often is a corporation. Why would you want to have a corporation as a trustee and not a natural person? Because corporations can't die. And if it can be very, very awkward if trustees happen to die at the same time when you're trying to go through and resolve an estate. So that you can set things up, inter vivos trust, while you're alive and have them carry on smoothly after you die. So that can be a very, very useful thing. There's also a thing called remote vesting, which I didn't put on the list, probably should have, which is to set things up in terms of things like life estates in the future, so that this can be held on trust for the duration or life of this particular person, then pass to another, and then possibly to another. What's the cap on that? What is the cap in terms of duration? Queensland has the wait and see rule. What's the cap in Queensland? Come on, what's the rule against perpetuities? What's the length of time in Queensland? How many years? No, that's the common law one. What's the, really? Rule against perpetuities in the state of Queensland. How many years must things vest in? So trusts can only be set up. Really? Come on, guys. Okay, it's 80. It's 80 years. Now you can go through and set these things up, but just note, when you're drafting these things as solicitors, they have to vest within 80 years. So there can be some ways around that with things like corporations. Asset protection is another really important one. If I have a house, and I'm literally just going through this at the moment, and going through a separation, and legal title is going to be vested in me, I'm not going to do that. I'm going to vest it in the hands of my trustee, which at the moment is also me. But leaving that aside, why? Because it separates the benefits and the burdens of the property. The benefits, the equitable interest, is going to be owned by my child and also me. But that's a really important thing, because if I go broke, if I go bankrupt, which, by the way, you as solicitors, you never ever want to do not go bankrupt as a solicitor. It's very, very bad. I actually don't think you can practice. Once that happens, if I do go broke for whatever reason, I'm not going to lose my house, provided I'm not doing it with imminent dark clouds on the horizon, i.e. within usually a couple of years of bad things happening. Low-risk commercial operations and superannuation. Super funds are all set up as trusts. So if you want to have a self-managed super fund, you want to do this yourself, the people running that, be it yourself or some others, are going to be, actually I don't think it'd be yourself, it has to be someone else. They must operate as trustees. So these rules you're learning for this are exactly the same rules you're going to do. I would recommend for you guys, particularly that are intending to be good capitalists, go out, earn a lot, save a lot, and have a lot in the course of your lives, learn these rules, create your own self-managed super fund at some stage in your life when you've got enough stuff. Charitable purposes. You can leave money to charity and do it in the form of a trust. So the board is appointed and they are obliged to do the thing that you wanted them to do in terms of that charitable purpose. The very last point that you won't see in the textbooks, because I added it in here, is actually to do with long-term sustainable operations, particularly of things like businesses. You can run businesses under a trust. It's usually not a good idea, because duties of trustee and the duties of a company director are vastly different. So that trustees operating a business can't take normal business risks as part of doing that. They can't, they're not obliged to. Trustees must act as very prudent investors and business persons with the intention of maintaining the capital. Okay, so if anybody here doing business as well as law, there probably should be a bunch of you in here somewhere. Yeah, the other day. So you guys appreciate, maybe everyone appreciates that trade-off between risk and return. Risky investment, you need to have a higher return. So, I'm not going to get my little awesome MS Paint diagrams out, but basically trustees, even though you might have high yield, a high risk return, trustees can't take that path. They have to do the low risk investments, largely because lawyers and judges are not business people. When these cases come up, these things can, often the judges will come back and say, why did you take a risky investment? Why would you do that? And it's like, well, Your Honor, actually, if on the little graph, this is a high risk, high return venture. So I think we're going to leave it there. 12:51. I'm going to leave it there, guys. So I don't have anything else to add in this part, but that's basically all of trust law inside 90 minutes. If you never come back to this class, I hope you learn some stuff. And we're going to have shoots next week. As you're aware, the lecture for next week won't be next week. It's going to be on the Monday afterwards. But there will be the shoot, which is on the Wednesday. And so I'll see some fraction of you guys hopefully there.